with the legal issues of Aboriginous people. You call it First Nation.
First Nations.
First Nation in Canada. She will be able to share some knowledge about your queries to heart, if any, about the legal system of Canada and how that legal system particularly address the issue of First Nation people, and a few questions from immigration, what they want from rest of the world and how they intend to treat them.
As Prashanta said, my name is Jodi MacIntosh and I come from New Brunswick, which is a province on the east coast of Canada. Have any of you here ever been to Canada? Show of hands. Anyone? No? Okay. When I say Canada, what's the first thing you think?
It's a nice country.
Nice country and cold.
Cold country.
Well, you're right on both counts. It is a nice country and it is cold. Right now, when I left Monday night, I left in the start of a snowstorm. Just a little snowstorm. It only delayed my plane by an hour and a half while they de-iced it. It's about the same temperature there that it is here, except this is just about as cold as it gets here, but it gets progressively colder until February, when it then begins to warm up again. But other than the fact that it's a very nice country and it's very cold, we have an interesting history. I'm not sure if any of you are familiar with Canadian history, so I thought before I started talking about fiduciary duty, which is sort of going to be the focus of the lecture, I would begin by giving you a rundown on, a little bit of a rundown on Canada and our history specifically with First Nations peoples. Now, the First Nations peoples, otherwise known as Aboriginals, have resided in what is now Canada, the US, North America, for more than 10,000 years. To put it simply, they were there first. They were there long before Europeans ever even knew that North America existed. And that fact in and of itself is sort of the basis from which we move forward. Just by way of a little bit of background, as Prashanta said, I lived here in London for a while, and I returned to Canada in 2007. And at that time, I went to work for an organization called the North Shore Mi'kmaq District Council. And the North Shore Mi'kmaq District Council, or NSMDC, is a First Nations tribal council that consists of 7 First Nations. And those First Nations are Pabineau, Eel River Bar, Eel Ground Metaconagiag, Indian Island, Bucktouche, and Fort Folly. These are all small communities along the eastern coast of the province of New Brunswick. And by way of geography, New Brunswick is on the east coast of Canada. So it's the part of Canada that's closest to the UK. Now, just to give you some idea of the size, Canada is a huge country. Canada is the second, in terms of area, it's the second largest country in the world. The province of New Brunswick is about, in area, half the size of Bangladesh. Okay, Bangladesh has, what, is it 140 million people, or?
60 now.
160. Okay, so imagine an area about half the size of Bangladesh. You have 160 million, we have 800,000 people. So we have not nearly the population that you have, which means we have a lot more wider open spaces. Land is not scarce in Canada, and it is scarce here in Europe. It's even more scarce probably where most of you come from. But the idea of land and natural resources is one part of the reason why Europeans first decided to colonize North America. It's generally thought that Christopher Columbus discovered America. That's not true. Christopher Columbus was not only the person who didn't discover America, he wasn't even the first European to. The first Europeans were the Vikings. And they established a settlement in what is now known as Newfoundland in eastern Canada about 1,000 years ago. That settlement didn't last. The Vikings went home, and a few hundred years later, people like Jacques Cartier and Columbus then rediscovered, if you will, North America, and it began to become colonized for a number of reasons. Canada and the U.S. had at that time, and still do have, a lot of natural resources. Vast areas of forestry, plentiful fishing, you name it, they had it. And this represented, in the eyes of Europeans, a great commodity. And it is for this reason that Europeans colonized and settled North America. Now, there were in Canada, there were sort of two major countries that were fighting over the territory. One of them was the British, and the other was the French. And Canada is officially bilingual. We speak both English and French. Most people do, I don't. But and that history goes back several hundred years. There was a war called the 7 Years' War, and at the end of the 7 Years' War, the French lost, the British won, the French went home, or at least the French government went home. Many of the French settlers stayed, and that's why many Canadians today speak French. But I say all that to say this. What we ended up with at the end of the 7 Years' War was something called the Royal Proclamation of 1763. And the Royal Proclamation of 1763 was issued by King George of Britain, right here out of London. And basically the purpose of this proclamation was to organize Great Britain's new North American empire and stabilize relations with the native North Americans through the regulation of trade, settlement, and land purchases on the western frontier. Now, the Royal Proclamation of 1763 is a really important document for Canada's First Nations people, because that's the document in which the government, which the King, the Crown, recognized that Aboriginals have rights. Now, what happened when the Europeans first made contact with the First Nations people? Winters in Canada were very harsh, and the settlers would not have survived had it not been for the First Nations peoples who taught them to hunt and fish and build homes out of birch bark. And their reward for this was by bringing diseases such as influenza to the First Nations people and effectively wiping out thousands and thousands of Indigenous people who were not used to these kinds of European diseases. So the first thing that happened with the contact was that a large portion of First Nations peoples were killed off simply because of disease. In terms of political alliances, most of the First Nations allied themselves with the French. And the French, as I mentioned, lost the 7 Years' War. So they had sided with the losing side. The Royal Proclamation was intended to sort of keep the peace, if you will, because what the British wanted was the land, and they wanted control of the land. But the land belonged to the First Nations people. They were there first. And in fact, their view of land is not as a commodity. Their view of land is tied very much to their spiritual beliefs. And their spiritual beliefs are that this land is not ours today, rather it belongs to our children. And we are merely keepers of this land for our children, and we cannot abuse it or misuse it in any way that is going to hinder our children from using it. We take only what we need and nothing more, and we do not exploit. For example, when they would kill a moose, I don't know if you know what a moose is. It's a rather large, ugly creature with long legs, but they are one of the national symbols of Canada. But when they would kill something like a moose, they would use every part of the moose, from the meat to the skin. Their belief is there is to be no waste of any kind. So the Royal Proclamation of 1763 was intended to sort of keep relations between the British and the British settlers in particular and First Nations people. It was intended to maintain peace. What it did, though, was it recognized the rights of First Nations people. The idea being, and there were treaties that would come over the years that the British Crown would sign with First Nations. And the interesting thing is that the First Nations and the Crown had very different views of what the treaties meant. First Nations have a history of oral tradition, which means they pass things down by word of mouth. Their stories they pass along to their children and their grandchildren through stories, orally. Now, the philosophy of and you learn this in contract law too. You have to have everything. That's why contracts are like this thick today, because you have to write everything down. And what it says in this piece of paper is what it is. And that was the attitude of the British Crown, was that what it says in the paper is what it is. But the First Nations view is that no, what we agree to orally or by a handshake is just as important, if not more important. And so the view with respect to land, the view of the First Nations was, we will share this land with you, and we will co-manage it together. The view of the British Crown was, it's ours. We've taken it. We've conquered it. And even to this day, First Nations people say, you never conquered us. You may have conquered, you may have won the war with France and kicked them out, but you never conquered us. You never took this land from us, and every bit of land is still ours. So this is sort of the backdrop, if you will, the history. There's a couple of other pieces of legislation that I just want to bring to your mind. The other is the Constitution Act of 1982. We have several legal documents that make up the Constitution in Canada. First one was the Constitution Act of 1867, which was originally called the British North America Act. That's the act that made Canada a country. It did not give us a great deal of independence from Britain, in the sense that every law that was passed still had to have approval right here in Britain. But over time, although Canada is still a constitutional monarchy and the Queen of England is still our head of state, we are, for all intents and purposes, separate from Britain. But that, unlike the United States, where they had an American Revolution in 1776, and that was it, they kicked the king out and have never had him back. It was a little bit different in Canada. But the Constitution Act of 1982 has a couple of provisions that pertain to First Nations people, and I'm just going to read them to you. The first one is Section 25 of the Constitution Act of 1982 that says, the guarantees in this charter of certain rights and freedoms shall not be construed as to abrogate or derogate from any Aboriginal treaty or other rights or freedoms that pertain to the Aboriginal peoples of Canada, including any rights or freedoms that have been recognized in the Royal Proclamation of October 7, 1763, and any rights or freedoms that now exist by way of land claims, agreements, or may be so acquired. That's Section 25. Section 35(1) states that the existing Aboriginal and treaty rights of Aboriginal peoples of Canada are hereby recognized and affirmed. Now, the Canadian Constitution is the highest form of law in Canada. And these rights are now, they existed before the Constitution, but by being put in there, they now become part of our highest law. And it is the law which with the Supreme Court of Canada gives the most importance and prevalence to. There's another piece of legislation which is in place here, which has been around since 1876, and which is regarded generally in Canada as being probably the most racist piece of legislation, I hate to say that, in existence, and that is something called the Indian Act. Now, Indian is the title that was once commonly referred to as Canada's First Nations people. They're not called Indians anymore. In fact, it's considered very politically incorrect and somewhat racist to use that term, because it refers to this ignorance that the European settlers first had, that they thought when they landed in North America, they actually thought they had landed in India. And so although the term Indian is not commonly used to describe Aboriginal peoples anymore, it is nevertheless the name of the legislation that governs them and their rights. It's also the name of the government department, the Department of Indian and Northern Affairs. So although we refer to Canada's First Nations peoples as either First Nation or Native or Aboriginal, legally they are still referred to as Indians. The Indian Act is a statute that was enacted in 1876 under the provision of 91 of the Constitution. Now, Canada's Constitution, we have sort of a division of powers. We have 10 provinces in Canada. And there are some things that are exclusively within the jurisdiction of our provinces, things like healthcare and education. But there are other things that are exclusively within the jurisdiction of the federal government, things like criminal law. And Indians and Indian land, under Section 9124 of the Constitution, fall exclusively within federal jurisdiction, which creates some degree of difficulty, because there are some things like healthcare that fall within the provinces. So the question then becomes, well, who's in charge of health care on a First Nation reserve? Is it the federal government? Is it the provinces? But the Indian Act gives the authority to the federal government, the exclusive authority to legislate over things known as lands reserved for Indians. So basically what happened is, through the process of having their land taken away from them, First Nations people were placed on Crown land belonging to the Crown that was reserved for them and for their use. And this land is called reserve land, or a reserve. Now, reserve land belongs to the Queen. It is land that is in the name of Her Majesty, but it is reserved in trust for Canada's First Nations peoples. But because it's in the name of the Crown, the First Nations, the reserves, have, by virtue of the Indian Act, they have a limit on what they can do with this land. Basically, the rule is a First Nation or a band, which has a government that is elected. They have a chief and a council, and the number of councillors they have depends on how big the community is. But the First Nations can do nothing with their land. Absolutely nothing. They can't lease it, they can't sell it, they can't designate it, they can't do anything with it without the consent of the Crown. And the Indian Act has a great deal of restrictions on it. It even restricts how they can dispose of their property. This is a very unique relationship in Canada. There's no other ethnic group that has this kind of relationship, and it's tied back to the history. Now, the hope of Canada's First Nations people is to someday achieve what they call self-government. And it's not a new term. It's been around for a long time, and there have definitely been some steps in the right direction. But the restrictions, because of the Indian Act, still make it impossible for them to deal with their own land in a way that is autonomous. For example, there are some First Nations that have prime land very close to an urban area, and a non-First Nation company might approach them and say, "We'd like to lease some of your land so that we can put up a convenience store or a shopping mall." And the First Nation might be agreeable to that because they can receive some of the they can receive rental income. They might even be able to negotiate to receive some of the profits. But before they can do that, the band might be in agreement, but the government has to be in agreement. And in order for the government to sign off on a lease, because the lease is actually signed by the government, the First Nation has to relinquish control of that land to the government. And then the government will enter into the lease. Are there any questions at this point about the history? I've gone through it rather quick, and I apologize because it's like 1,000 years of history. But are there any questions at this point? Yes?
The word, the Aboriginals, the first people, like when I hear about the Aboriginals, the first thing that comes to my mind is they are in Australia, not Canada.
Not in Canada.
It's very strange to hear that there are also Aboriginals in Canada.
Okay.
And also the Aboriginals in Australia. I understand they are like red-colored people with no dresses. So, what is the relationship?
What, between them?
Yes.
It's a good question because there are many countries in the world, many countries, not just Canada, not just Australia, that have Indigenous peoples. When you think about the history of wars, for example, I mean, Britain is a perfect example, and not to pick on Britain, I love Britain, but the British had a history of colonization. Britain's a very tiny country. It's an island, and they have limited resources. There's not a whole lot they can grow here, and they needed more land. And part of the quest of the British and Europeans was to go out and seek land elsewhere. And North America was this great, much like Australia, was sort of this great, vast amount of land with these resources. But in all of these places, there were people who lived there first. They were untouched from the rest of the world. They had no contact with the rest of the world. And it wasn't until these people with these white faces showed up. And, you know, you can imagine what, you know, how shocking it must have been for them. The Europeans knew they were going in search of something else, and they knew they would find people, but the Aboriginal people probably didn't know what the heck to think when they first saw Europeans. In terms of ethnicity, it's believed that they probably migrated from somewhere in Asia when the Russia and Alaska are very closely connected. They used to be connected by land. So that's likely where they immigrated from. First Nations people, in terms of their physical appearance in Canada, there's been a lot of intermarriage over the years. So there actually are some First Nations people who look much like I do. They're quite fair-skinned, but 500 years ago, when they first made contact with Europeans, they didn't look too much like me. They were darker skinned, and the Aborigines of Australia, I think there's been less intermarriage, perhaps. But yeah, the Indigenous peoples, you find them everywhere. You find them in Australia, you find them in Africa. And interestingly, the policies that the British used in Canada are very similar to where they used everywhere. Based on what I've read, the treatment of the Australian Aborigines was worse than the treatment of the Aboriginals or the American Indians in the U.S. was far worse than what you see in Canada. But nevertheless, the treatment was not good. They were, not that they were living in harmony. Yes, there was fighting. There were wars, but the contact with Europeans changed their life, changed their world, and for the most, it wasn't for the good. And the most crucial loss, really, was the loss of their land. You could imagine what it would be like to be living in some place for thousands of years, and then somebody else just marches in and says, you know, sticks a flag in the ground and says, I declare this land on behalf of His Majesty the King. And so it's been a hard-fought battle, and it's only been in recent decades that the Canadian government and the Canadian legal system, the courts, have recognized and affirmed the rights of Aboriginal peoples. Did you have any other questions?
Is that true, like you are still paying the Queen every year? I mean,
that we still pay, yes, we do.
But you're going to pay forever, or you're going to stop at some point?
That's a good question. There's an ongoing debate. I think it's a debate in Australia. It's a debate in most Commonwealth countries. The question is, yes, the Queen is still our head of state. Will she remain the head of state? I think it probably comes down to public opinion. As of right now, the majority of Canadians...
How does she represent? The Governor General?
Yes, she's represented federally through the Governor General, and in each province she's represented by a Lieutenant Governor. And basically no law, this is interesting, no law in Canada can become a law, no bill in Canada can become a law until it has received royal assent. We have two levels in our Houses of Parliament. We have the House of Commons and we have the Senate. The House of Commons is elected, the Senate is appointed, although there's talk that they might become elected as well. But even once a bill passes, clears through both houses, it's still not a law until it's received royal assent. Although it is basically just rubber stamping it. The Lieutenant Governor or the Governor General doesn't really have the right to say, no, I'm not going to sign this. So the Queen is largely, much like here, largely a figurehead. Yeah.
Is she practically of any benefits to the nation? And can they not do, I mean, being a very civilized country, can they not do without her? Is there not any way they can get rid of her?
Get rid of her?
Well, not physically.
No, I know what you mean. Can we choose to go the way of the U.S. and become a republic? The answer is yes. It would require an amendment to our Constitution, which would require a referendum. And I think it would require a 2/3 majority, either 2/3 or majority. I'm not quite sure on that, but the answer is there is an increasing minority of people who say, what do we need a monarchy for? And it's an ongoing debate, and it's, you know, one way or the other. Some people are Republicans, some people are Royalists. But right now, as it stands in Canada, the majority of people still see some benefit to the monarchy, which is why the Queen is still on her money. And she and Prince Philip, I think, came for a visit this past year. Yeah, and she's well into her 80s, but the Queen has a great deal of respect in Canada. She does. You know, she's been the monarch for over 50 years, and I think there is a great sense of respect. But you know, how people feel one way or the other about a monarchy is, I guess, a matter of personal opinion. And until it reaches that point in Canada where the majority of people say no, then we'll still have a queen. But it would require a change to our constitution to do that, which is easier said than done. Easier said than done. So what I want to do now, how am I doing for time? Okay. What I want to do now is just highlight one of the legal concepts that you've probably come in contact with. I don't know. Are you familiar with the term fiduciary duty?
Still, you didn't go there.
You haven't gone there yet? Okay, well you will at some point in time. You'll come across fiduciary duty. So I'll just talk very briefly about it, and then I'll talk about how that ties into an Aboriginal case known as the Queen versus Garing. A fiduciary duty is a legal or ethical relationship of confidence or trust regarding the management of money or property between two parties, most commonly a fiduciary and a beneficiary. It is the highest standard of care at either equity or law. A fiduciary relationship will exist when one person, who is known as a fiduciary, has unilateral control over the interests of another, and that other person is known as a beneficiary or principal. Wherever these conditions are met, the law will hold the fiduciary to a high standard of conduct. The fiduciary must act solely in the best interest of the beneficiary and be loyal and careful regarding the beneficiary's interests and assets. Fiduciary law protects those who trust in others from having that trust betrayed or misused. When a fiduciary duty is imposed, equity requires a stricter standard of behavior than the comparable tortious duty of care. If you've taken tort law, you've come in contact with duty of care. If you haven't taken it yet, you will, because duty of care is really all what tort law is about. Well, fiduciary duty is a higher level of duty. It goes above and beyond the standard sort of duty of care that you find in tort law. The fiduciary has an obligation not to put themselves in a conflict of interest. In a situation where their own interest would conflict with the individual, or in the case of the Canadian government, the individuals that it has a duty to protect. Fiduciary obligations are not the product of any statute. You won't find it in a statute. It's the product of case law. It's been developed by the courts. And it arises in various different situations, so it evolves. And it'll exist where the courts find that the situation warrants it, where it is fair and just. And when I use words like fair and just, I ask you, where do you think fiduciary duty might have first evolved from? When I use words like fair and just and equitable. Equity, right. Fiduciary duty existed here in England in the courts of equity. And I'm sure you've all studied the courts of equity. Equity is where you went to obtain a certain, if you had a certain type of grievance and you wanted to obtain a certain type of remedy. Now, of course, the courts of equity and common law have merged in this country. So this is an equitable doctrine that you can receive relief for at common law. In order for there to be a fiduciary relationship or a fiduciary obligation, three things have to exist. One person, the fiduciary, has to have an obligation to act on behalf of another. Secondly, the fiduciary has unilateral control over the interests of the beneficiary. This is a power or a discretion over the interests of the beneficiary, and the beneficiary has no control over their own interests or assets. Thirdly, the beneficiary is vulnerable to the fiduciary misusing position of power. Now, as I've described the First Nations relationship with the Crown in Canada, it's not hard to see the argument that the government, the Canadian government, the Crown, has an obligation to First Nations people, because through years of history and government legislation, a lot of the rights that the Aboriginal peoples of Canada had were taken away from them. The idea being, and it sounds awful and kind of embarrassing, but the idea of the British Crown was these people can't look after themselves, much like children. We have to look after them. We are their keepers. We are their guardians. Hence the legislation like the Indian Act. So it's not hard to see how a court would say, okay, fine, if that's the way you think you are, if you're going to take these kinds of powers from them with respect to how they manage their own land, and you're going to manage it for them, it's going to place you in a fiduciary relationship. It's going to put you in a relationship where you have to act in the best interests of these individuals. So the landmark case, which is the case that I'm going to talk about for the next couple of minutes, is the case of R versus Guerin, or the Queen versus Guerin. Now this case took place out in British Columbia in the city of Vancouver. Have any of you heard of Vancouver?
Yeah,
it's quite a big city, yeah. It's one of our biggest, and we just hosted the Winter Olympics earlier this year in Vancouver. Well, there's a number of First Nations in the Vancouver area, and one of them is the Musqueam First Nation. Musqueam is located, it's reserve land located basically right in the middle of Vancouver. Vancouver has some of the most expensive property in the country, some of the most expensive property in the world, and it's prime location. And the owners of a golf club approached the government, the Canadian government, because they wanted to lease some First Nation reserved land from the band so that they could expand their golf course. And of course they had to go to the government, and it was up to the government to say yes or no. But the government has an obligation to consult with First Nations. So government representatives had a meeting, much like in a room much like this, with the chief and council and community members from the Musqueam First Nation, and said, look, they want to lease 160 acres of land, and they want to lease it for 75 years. And in return, they'll agree to paying rental income. And after consultation with the community said, okay, we'll agree to it, but there are a number of terms we want put in here. We want to be able to renegotiate. You know, we want our values respected. And so the government went back to the golf club and said, okay, we'll sign off on the lease. But what the government didn't do was they left a few important facts out. They didn't give when they met with the First Nations, they didn't give them the whole story. And They also agreed to they agreed to a lease that was very unbeneficial to the First Nations. The amount of rent that was agreed to was ridiculously low. They weren't allowed to renegotiate the terms of the lease, including the rental income. Basically, the government agreed to a very bad lease. And they neglected to put in the terms and conditions that the First Nation had asked for. In short, they did a really bad job. And it was 12 years before the First Nation, despite numerous requests, it was 12 years before they actually were able to see a copy of the lease. And once they finally got a copy of the lease, they realized that the lease was not at all in their favor. And so they sued. They sued the government. They didn't sue the golf club. They sued the government. And they sued the government on the grounds that you had an obligation. You had a fiduciary obligation to protect our interests, and you didn't. It went to trial, and the trial judge agreed. They found that there was a fiduciary relationship. On appeal, it was thrown out, and so the band then applied to the Supreme Court of Canada for leave to appeal. And at trial, the trial judge awarded them, now this was in the, when was the trial? The trial was probably in the early 80s. The trial judge awarded them 10 million Canadian dollars, which is about 6 million pounds. And the Supreme Court of Canada agreed to hear the case. And there were, I think there were 9 judges sitting, and they unanimously held, they overturned the appeal judge's decision, reinstated the trial judge's decision, and they unanimously held that yes, the government owes, in this case, they owe a fiduciary duty to the First Nation. And this is what the majority said. The majority stated that the interest in Aboriginal land is an independent legal right that existed prior to the signing of the Royal Proclamation of 1763. So this right predates it, goes before that. The Royal Proclamation merely solidified it in paper form. The Crown's obligations are trust-like in nature, and the scheme for disposing of Indian title creates a fiduciary duty for the Crown to deal with the land for the benefit of the band. This fiduciary duty has its roots in the concept of Aboriginal title, and the conclusion that the Crown has a fiduciary obligation is dependent on the proposition that Indian interest in land is inalienable except upon surrender to the Crown. Whereby statute, agreement, or unilateral undertaking, one party has an obligation to act for the benefit of another, and that obligation carries with it a discretionary power. The party thus empowered becomes a fiduciary, and in this case the fiduciary will be held to a strict standard of conduct. The fiduciary obligation that the Crown has to First Nations is unique in nature under Canadian law. Section 18(1) of the Indian Act gives the Crown a broad discretion in dealing with land that has been surrendered, because what the band has to do is surrender their interest to the Crown before the lease can be signed. And where the land has been surrendered, a fiduciary obligation arises that requires the Crown to act in the best interest of the band. In this case, the band had stipulated a number of oral terms that were to be integrated into the lease, and the officials from the government, Indian Affairs, had induced the band to surrender the lands on the condition that the terms would be honored. The Crown obtained rent for the land at a rate much lower than the market value and without further consultation with the band, and thus breached its fiduciary duty. So the Supreme Court of Canada reinstated the $10 million award. and also stipulated that the band could go back where this happened, is actually one of the most progressive First Nations in the country. And because of its location, you know, it's got shopping malls, it's got banks, it's got everything. They do quite well financially, but this is a case of where the government had breached its duty. Now, the decision in Garin actually had a wide-ranging impact. This is sort of like the case dealing with fiduciary duty, but it's been used as the benchmark to interpret Section 35(1) of the Constitution Act, which recognizes and affirms the existing Aboriginal and treaty rights of Aboriginal peoples of Canada. And the last thing I want to touch on, just briefly, is with respect to treaties in Canada. Treaties have been signed in Canada going back several hundred years. There are different nations or tribal groups in Canada, and they entered into separate agreements with the Crown. The interesting thing is that the way the Crown saw the treaties and the way the First Nations saw it, as I said before, were not the same. First Nations saw it as, we're sharing the land with you, and the Crown saw it as, we're taking the land. But there has been, in recent years, there's been an acknowledgement, largely through case law, but also through the government acknowledging that it's time to recognize these treaties. They've been around for hundreds of years. They've now been interpreted by the courts, and they've been affirmed. And basically, in a nutshell, what the courts have said was, you signed these in good faith, and you have not, it's not enough to sort of follow the letter of the law. You have to follow the spirit of these treaties. And you, the Canadian government, have not been doing that. So what they recently, just this past summer, in the province of Nova Scotia, which is just the province next door to where I live, 3 levels of government, the First Nation government, the provincial government, and the federal government, have entered into a tripartite relationship. And what they're trying to do is any activities that the government, either level of government, the provincial or the federal, are going to enter into, which may have an impact on First Nations rights. First Nations have to now be consulted. There is a duty to consult First Nations, but there's also a duty to accommodate their interests. It's not enough to simply get everyone together in a meeting and say, okay, we've consulted with you. We've told you that we're going to build a highway. We're going to put it right through an Indian burial ground. There, we've told you that we're going to do it. No, no, no. Consultation is not enough. You have to accommodate. And that means you may have to move the highway. You may have to actually, and there have been cases where the highway has been diverted around an Indian burial ground. It's not enough to simply consult. There's also a duty to accommodate. And it's hoped with agreements like these tripartite, this whole treaty process that started in Nova Scotia and is moving into New Brunswick, it's hoped that in the future the relationships between Canada's First Nations peoples and the government can start to heal. There's a great deal of mistrust there. But the great thing about the First Nations people is that they have been willing to forgive. They have been willing to continue on in a relationship even when there have been times that they were lied to and mistreated. And it's hoped that through better communication and need be case law, you know. Some of the most important jurisprudence that's come out of the Supreme Court of Canada has dealt with Aboriginal law. It's hoped that things will improve for First Nations people. They have a lot of social problems, things like drug abuse and poverty and alcohol abuse and unemployment. are pretty high among these communities. And through economic self-sufficiency and having better control and management over their own affairs, being able to sort of take back what was once theirs, that things can improve for this group of people, because their culture and their history is so interesting. And I want to close, I'll open it up to questions that you have, but I want to close by teaching you a Mi'kmaq word. The Mi'kmaq peoples are the peoples who live in New Brunswick, where I come from. And the Mi'kmaq word for thank you is Walali. So, Walali, thank you for allowing me to come and speak to you today. I really appreciate it, and thank you to my friend Prashanta for giving me the chance. And if you have any questions, please feel free to ask.
I would like to say something about constitutional affairs, like Canadian government, Australian government, like UK's government. My question is this, that what's the difference between Canadian constitution, Australian constitution, and UK's constitution? And which one is better for you as per your opinion? Can you give me some? Can you give me main difference?
The main difference
UK, Australia, and UK's constitution.
Okay.
That's it.
In terms of Australia, I have to plead ignorance. I don't really know much about Australia's constitution. Do you? I don't either. Britain's constitution is, they don't have a written constitution.
Which one is better?
Which one is better? Well, you know, the Canadian Constitution, we have sort of two pieces of the Constitution. Is in Canada is several documents. It's not one document. The first one, as I said, was the British North America Act. Now, the British North America Act created Canada, made it a dominion. And Canada consisted originally of 4 provinces. One of them was New Brunswick, where I come from, Nova Scotia, Ontario, which is where Toronto is, and Quebec, which is where Montreal is located. And the other thing that it did, and I touched on this, is this division of powers that we have. Section 91 lists the powers that the federal government has. Section 92 lists the powers that the provinces have. And if you look at our constitutional case law from like about the 1890s, well into the middle of the 1900s, there was an awful lot of case law that dealt with this Section 91 versus Section 92. In other words, the provinces and the feds are in this constant, get out of my face, you're in my jurisdiction kind of battle. And this battle's been going on. It makes for some interesting case law, but the result is there are certain things, like education, for example, that is not cohesive across Canada, because education is, and same with healthcare, they fall under provincial jurisdictions. I don't know that that's a good thing or a bad thing, but you don't find that here in Britain. The other thing, which I think though is a very good thing, and this is just completely reformed criminal law and human rights law in Canada, was the Constitution Act of 1982. And the Constitution Act of 1982 brought in the Charter of Rights and Freedoms. That's part of the 1982 Act. It's the big part and arguably the most important part. And what that does is that guarantees certain things like the right to seek legal counsel if you are arrested or detained. It prevents discrimination on the grounds of race, religion, language, creed, color. And that's been incredibly valuable. It's not that, you know, it's not that there weren't laws before 1982 that prevented these things, but now they're part of our Constitution. And the Constitution, as I said, is the highest law in Canada. It's generally the highest law in any land. And I think our charter has been incredibly, incredibly valuable to Canadian citizens. There have been, since 1982, the Supreme Court of Canada has spent probably most of its time in interpreting the charter. And it's just from the perspective of a Canadian, it's our most important piece of legislation, you know, and the fact that, like I say, the fact that it's in our Constitution, and our Constitution is very hard to change. It requires basically the ratification of all of the provinces, all of the provincial governments, and the majority of the Canadian people.
What is your personal experience, whether practicing over in UK is better or practicing in Canada if someone get any opportunity to continue with it?
In terms of the law, you know, Canadian and British law are very similar. They are. Like when I took, for example, contract law, or contract law is a perfect example. Most of the contract law cases I studied, I'd say at least 2/3 were from the House of Lords. They were British cases. There are other areas of law, for example, constitutional law, where we don't study any British cases. Surprisingly enough, in Canada, we study far more, in terms of comparative, we study far more British law than we do American. The American legal system is quite different from the Canadian legal system in terms of the way the courts are structured. The Canadian political system, the Canadian legal system is modeled on this country. It's modeled on the British system. And your question with respect to where to study, or where to practice. I never practiced here in the UK. One of the big distinctions is that here you have barristers or solicitors, and in Canada you're a barrister and a solicitor, so you can do both. Now, from my perspective, I preferred being a solicitor. I didn't enjoy courtroom work. It was not really my thing. But in Canada, you can expect that you will do both in your practice. In terms of where to go to practice, I think the life of a law firm in a big city like this is probably quite similar. It's exhausting and it's overwhelming. I practiced in a good-sized firm, and it's very fast-paced. And I think in that respect, it's the same as it is here. The big distinction is that, you know, in Canada you can expect to be a barrister and a solicitor.
Okay, I have different questions. If I ask them, would you remember to answer them separately?
Okay, you have to remember.
So I don't raise up my hand again.
Okay.
First of all, you are from one of the First Nation countries. Is there visibly anybody hold their crown, or like the government?
Okay.
Because obviously the government is an invisible person. For instance, if I'm working for council and then you come to me, I am the government, I tell you this is the law. So basically, is there anybody you can see and say, I'm from the First Nations, you are not, like the First Nations and the government? Who, as in practically, are they like visibly there?
Do you mean, is there anyone from First Nations who works for the government?
No. Can you make a difference? For instance, I can say they are British or they are Scottish. So you are from the First Nations.
I myself am not First Nation.
Okay.
I'm not. I'm of, my surname is MacIntosh. I'm of British origin, actually. Scottish.
Okay.
Scott.
But in terms of identification of being First Nations, that's an interesting question, because there are actually three types of Aboriginal, three sort of broad Aboriginal groups. There are the Métis. Have any of you ever heard the term Métis before? Métis people were individuals whose, and this is going back hundreds of years, but they are of mixed race. They are the children of generally Aboriginal mothers, and their fathers were French fur traders way back in the day when fur trading. So they are by nature of mixed race. And then the other group are the Inuits of the north, which were commonly called Eskimos. We don't use the term Eskimo anymore. They're referred to as Inuits. And basically everyone else who is Aboriginal identifies as First Nation. But in terms of how you identify yourself as First Nation, it's a very good question, because the way the government identifies First Nation and the way someone else may identify themselves are not necessarily the same. But in terms of the rights, many of the rights that are afforded to First Nations people, the government under the Indian Act has a set of criteria. And if you meet that criteria, you become what is known as a status Indian. And you actually carry a card with your photograph on it that says, with a number, that says you're a status Indian. So for example, if you are a status Indian, you have certain exemptions. One of them is an exemption from, in certain circumstances, an exemption from paying income tax. If you are a status Indian and you work either on a First Nation reserve or for a First Nation company, you are exempt from paying income tax. Now, that's a big deal. You know, that can be, our taxes aren't quite as high as they are in the UK, but you can pay almost a third of your income in tax. And if you are a status Indian, depending on the circumstances, you're exempt from paying income tax. But you have to have a status card.
How much is that?
What? How much is that? Well, they're free if you've got the right criteria. You're not the first person to ask that question.
He wants to buy one.
Yeah. But there are some people, for example, there are in the province of New Brunswick, there are approximately 40,000 Mi'kmaq people. 40,000 individuals who identify themselves as Mi'kmaq. Not all of them would be status Indians. And it has to do with your, you have to prove a certain amount of parentage, basically. It goes back to your grandparents, because there are a lot of, there has been a lot of intermarriage. So it's basically, I think it's about 1/6. I think it's 1/6 that you have to establish in your family tree. Yeah, to gain status.
Any other question from other side? Any question?
One more.
Okay.
So currently, what is your state of immigration welcoming for foreigners, and also what is the condition of the immigrants in the country? For instance, you welcome them. Do you have restrictions for them in terms of, for instance, here there are some jobs you can want to go for, and then they said you have to have a British passport or an indefinite leave. Do you have that tag, you know, on your immigrants, or you welcome them and they're free to practice any qualification there?
Okay. Let me premise this first of all by saying I'm not an immigration lawyer. So if any of you are thinking of moving to Canada, and I hope some of you will, please obtain legal advice. But just by way of
the total population in Canada.
The total population of Canada, as I said, is the second largest country in the world in area. We have a population of just under 35 million people. Most of the, yes, I know you giggle and laugh. That's like what, the size of your capital city or something. Most Canadians live within 200 miles of the United States border. So most Canadians live along the southern band. And the reason for that is quite simple. It's just too cold further north. Our immigration policy in Canada, the citizens of Canada, the population of Canada, we have a declining birth rate. We actually don't produce enough children in Canada. And for that reason, immigration has become much more prevalent and popular. We've always had an open immigration policy. We've always been, much like the U.S., which describes itself as the melting pot. Canada is is very much the same, and we do have an open door policy. With respect to actual restrictions on immigration, there is a point system that's much like the British one. It's based on skills, it's based on education. You have to prove that you have something to bring to the country. Canada has a pretty strict policy of not allowing, not that this applies to any of you here, but it has a strict policy of not allowing entrance to convicted criminals. So if people have criminal records, even if they want to come for a visit, I'm not talking about going to live, even if they want to come for a visit, you will likely be turned away at the border. Our view, I guess, is that we have enough criminals in our own country. We don't want any more.
Enough criminals in Canada.
There's enough already. We don't need any more. Once you're here, and you pretty much can pursue whatever vocation you want in Canada. But I have a friend who's from India who recently gained his Canadian citizenship. It took 5 years. And the same thing that you have to, I know in Britain there's been some talk about in terms of reform. Like, it seems like every time you turn around, Britain is changing its immigration rules. Not that we don't change them in Canada, but we don't seem to flip-flop nearly as much as the British do. Every time you turn around, they've got new rules. It's almost like they don't quite know how to deal with immigration here. They can't figure out which is best. I think our system seems to be a bit more settled, but definitely we allow an increasing number of immigrants to enter Canada every year. But it is based on a point system. It is.
Now it is time to end. We understand that it does not relate directly and immediately with your chapter of study here, but as we discussed in earlier class as a student of law, we need to know many things, which who knows, it can be relevant in your future case. In Bangladesh, in India, in other jurisdictions as well, they have Aboriginal people, Indigenous people. You might lead a case on that. One thing I forgot to ask you, how the property right or land right of those First Nation people determined? Does this still require the paper document? Or
yeah, the property rights.
Customary occupation.
Property rights of First Nations people. It's all to a large degree governed by the Indian Act.
Okay.
Even estate planning, making will and how your property is disposed of is all governed by the Indian Act. It's not just land rights. It's also to a degree personal.
I believe then you can say your concluding remark to London Spring College and Law students.
I wish you all the very best of luck in your future endeavors, and as an ambassador of Canada to you all, I say if you ever get the chance to come and visit, please do. Don't come in January or February unless you really want to freeze. But Prashanta was asking me when a good time to come and visit is. Our summers are lovely. August and September. September's my favorite month of the year. So please, if you ever get the chance to come, do for a visit. And if you do, some of you might even be convinced to stay.
Okay, then thank you very much for your patience, and we borrowed your ears
yes.
for last 1 hour. And thank you, Jodi.
Thank you.